Hello everyone, I am Jishu Prakash here. In this video, I will discuss about the importance of moot court for law students. So let's begin, because most of the law students will think that in the final year we can participate in a moot court because it is mandatory in the final year. There is a internal marks. For that reason, let's participate in the moot court in the final year. But normally, what is my opinion, that is my experience in the moot court, which will help you to understand why you need to begin the moot court in the first year itself. You need to understand the importance of moot court. So let's see why moot court matters. I will also share my own experience with you all. So there is a practical skills, advocacy, networking, so career boost. So I told I'm G. Shubhakashe, so I'm a law student and author. So here I will discuss one by one. First is mastering the courtroom. So the critical gap. What happens in the classroom and what happens while you delivering or you are convincing the judges in the moot court. In classroom, it is a legal theory, that is foundational knowledge. Abstract means summary. So principles and academic case analysis. So in colleges, what you will do in law colleges, you will read the law, that is theory. You will read the case laws and you will read the sections and various other material reference books for to clear the Karnataka State Law University examinations or other law university examinations. So out of Karnataka or entire India, I am discussing about the moot court importance. So whatever exam you are pursuing as a law, it doesn't matter which university, but when you are pursuing, you will focus on exam point of view, that is clearing the exam. So you will memorize everything like sections, case laws before the examination. This will happen in classroom legal theory. But what happens in the moot court? It is a practical courtroom litigation. That is, in the moot court, you will actually express yourself in front of bench, that is judges. So in classroom, you will listen. There is a listening skill will be there. In anything, you will get something, that is skills. Even you get in the classroom also and in moot court also. The skill varies. In classroom, you will listen, so listening skill will be improved. But in the moot court, you will speak, you will argue, that is communication skill will be improved, that is convincing others will be improved. You will try to convince the judges to move on to the next round. So that is moot court, that is real world strategy, evidence presentation and persuasive advocacy. How you will persuade the judges, like how you will convince, that matters the most. So you need both. It doesn't mean moot court is enough for law student or only classroom lecture is enough for law student. No, you need both. So both are uh, two sides of the same coin. So without one thing, we cannot follow next. If we only focus on college life, we unable to practice well in advocacy life. If we only focus on advocacy life, then there is no foundation for us to understand the law. So we need both. Let's move on next slide. That is simulated appellate. So understanding the moot court. So simulated appellate advocate. What is simulated? Like what is moot court? First of all, moot court is an imaginary court. That is, the imaginary cases will be given. There are two possibilities. One is pending case in the court that will be given to the moot court in the moot court for discussion. And another is imaginary case. Totally, maybe the facts is same, name is changed, or totally imagination possibility of filing the case in the future. So imaginary case will be given as a moot proposal, that is moot problem. So a structured oral argument in a simulated appellate court setting focusing on persuasive legal reasoning and case analysis. So based on that, like whatever facts they are giving, on that how you will convince the judges, that is bench. You need to analyze in the moot court. Interesting part is you need to analyze both the sides. that is petitioner side, who files the case, and respondent side, who defends their counsel, right? You need to prepare for both the sides. So law, not evidence, so you need to apply the law. It is not a trial advocacy that you need a witness. Moot court is completely different. So in trial advocacy there is a witness is needed, but in the moot court competition, whatever problem is given, that's enough to argue the case. So hypothetical legal issues, there is a legal issue, possible issue, maybe in future, or it may be imaginary issue based on fictitious case problem involving complex question of law rather than factual dispute. It is a question of law. There will be a question like fundamental right violations, or there will be other rights which are violated. There is a compensation needed to the client. How you will convince the judge to get higher compensation for your client? So next, points of statutory interpretation and constitutional law. Arguing the interpretation of statute, that is how you will argue with the help of sections and regulations and constitutional principle rather than presenting a new evidence. There is not about presenting a new evidence, it's about how you will present the case in sections, case laws. So everything you will include it in legal points. So no witness is required. As I told, trial advocacy competition is different and moot court is different. You can join any participant, and what my request is, start in first year itself. Don't wait for final years. Maybe some students thinking that in first year I don't know anything, I don't know law, then how can I participate in the moot courts? So first you need to observe your seniors. You need to assist them in their research as an assistant researcher, because some colleges allow three mooters, that is two mooters, one researcher, and some colleges allow even assistant researcher as well. But whether assistant researcher is allowed or not, it doesn't matter. First try to assist your seniors. Later you will understand the procedures. Then you will participate in first year itself. So that is my request, to participate in the beginning itself, so that when you come to final year you will be prepared. You will know the memorials, you will know how to draft the memorial in petitioner side, respondent side, you will know everything. In final year it is very easy to explain, to present the case in front of judges to get internal marks. So for internal marks purpose, do not focus on moot, focus for your knowledge purpose, because after getting completion of advocacy, you will practice in front of the judges. It may be district court judges, high court judges, or supreme court judges. So you need to present without fear. This moot court remove all the fears, so there is no stage fear. So best mooter can, what mooter can do, they can convince the persons, they can even manage the event without fear. So this is the people management will be improved. So legal counsel, that I said, in a team normally 3 persons. Some colleges allow 4% as an assistant researcher, but generally 3 persons. So handle constitute and core statutory arguments. Speaker one is mooter one. What his work is, his or her work is that to opening the case, like present the case, like discussing the facts of the case, like what are the main issues, and speaker 2 will be conclude it, like close it. So argue secondary issue and procedural points. And prayer, speaker 2 will handle, the co-counsel will handle prayer. Prayer means what you need from the court. Request, that is you need request, like compensation is needed for your client, so you are pleading in front of the court, that is requesting. So or you need a damages claim, or you need to punish the person, opponent counsel, that is opponent person who damaged your client's reputation. So what happens, these all are speaker 2. In prayer it will be discussed. So while praying, you need to keep your right hand in your chest, and even the counsel 1 and the researcher also need to stand and keep their right hand, because you are pleading, like requesting in front of the judges. So, and you will also cover that if above prayer is not satisfied to the bench, then please, in the nature of justice, you can decide any, you can give any judgment in the nature of justice. That is, you are giving the option to the judges that you are requesting. That if you unable to satisfy all points, you can do anything in basis of nature of justice. So next is the researcher role. Researcher is very important in moot court. So uncover precedents, drafts memorial, and assist counsel. So what is researcher work? Researcher do drafting, entire drafting. Even motor 1, motor 2 also can involve, but major portion work is researcher. The he or she who is the researcher knows very well which section to apply and which case law to apply, what to say and what not to say. If judge is asking the question, if counsel 1 or counsel 2, that is speaker 1, speaker 2, unable to answer, at that time researcher can write the sections or case laws in the chit, that is in small paper, and pass to the speaker 1 or speaker 2, whoever is handling the questions from the judge and unable to answer, because it is very difficult. It's easy to prepare and go. When we stand and present the case in front of the judges, even we know everything, but when the judges asking in-depth questions, difficult questions, we unable to answer, even we know, because maybe there is a pressure, time pressure, or there may be doubt that whether I am saying is right or not. If what if it is wrong, so what will happen? They will think and they will stop. That researcher helped assist the mooters, mooter 1 and mooter 2. So that now mooter will think, okay, researcher is given this topic, that is whatever I am thinking. So it is right. I can continue my case, argue. That is researcher role. So essential skill building, what you skills are building in this moot court. I already discussed with you. Communication skill will be improved, and your research skill will be improved if you are researcher, and you can convince easily others. Convincing is difficult part in life. Even if you try to convince anybody, even your friends, uh, even your judges, or even any persons, so it is very difficult to convince. So, um, essential skill building, cultivating the indispensable competencies demanded by litigators. So, you will know how to compete and what skill you are acquiring. First of all, what is your goal? In the first moot, do not expect prize. If you win first in the first moot prize, again congratulations. That is rarest case. But normally, what happens? First year students, it is difficult to proceed or clear the preliminary round itself. Why? Because opponents team are seniors, or they know the law already studied. You are just prepared now. You entered, you are new and you enter right now. So you are unable to present properly, or there is a coordination, lack of coordination in your team. So what happens? It is very difficult to clear preliminary stage. So my suggestion is, first you need to focus on learning. Later, after learning, that is first or second two moves, you will realize that whatever mistake you are doing, you will not repeat again, and you will easily clear preliminary round. You will qualify for quarterfinals. Uh, Quarterfinals means top 16 team will be qualified for quarterfinals, and octafinals, top 8 team will be qualified for octafinal, that is top 8, and semi-finals top 4 team will be qualified. And it is also very difficult, top 8 and top 4, while you are competing, it is very difficult because we don't know, it is an elimination round. Either your team will be proceed to next round or opponent team. So next is final. Again, that is amazing to see any finals of the moot court. And so what is my uh, plan for preparing this? To make you understand that first you need to prepare, train yourself. Later you can win the moot court. So let's continue. That is three pillar. exhaustive research. So moot court requires research. So what I said is researcher need to do. Even mooter 1 and mooter 2 also needed to understand the researcher's perspective. So mastering Westlaws, Lexnix and SCC online, that is Manupatra also. There are various softwares. You need to download the judgment and you need to read the judgment. So for persuasive authorities, so memorial drafting, again it is very challenging. If you don't know drafting, it's okay, you can refer your seniors memorial. But what my suggestion is, what is memorial is a written submission. In a written orally, what mooter is arguing, that all is mentioned in the written argument, that is draft, that is memorial. It includes index, that is page numbers, in what page number what are included, arguments like summary argument, which page number, and detailed arguments. So jurisdiction, so which jurisdiction you are applying for, which code, and what is issues for determinations, and finally prayer, that is what you required from the court. These are memorial drafting. So authority, you need to cite case laws, structural appellate brief with strict logical and rigorous citations. Next is oral presentation, that is mooter will handle it. So refining verbal communication, tone, posture, time management under scrutiny. You need to manage the time because there will be a 20 minutes or 25 minutes max to max. So both the mooter, that is mooter 1 and mooter 2, need to divide the time and they need to plan accordingly. So this is standard classroom lecture. So classroom lecture what 100 plus hours. So of legal research per competition, building lifelong analytical muscles, that is 3x greater depth. Means what? In classroom lecture, whatever you are learning, it is triple the effort of moot court, because here you are learning self, that is self learning. Even your moot court committee members will guide you and your seniors will guide you, so you will get an idea in multiple perspective. So you will also do the research and you will present the case. So there will be a researcher test also. If who are interested in the research, they some students are unable to speak in front of the judges, what they will do, they will escape from taking researcher role. So researcher, what happens, if you go in depth, there is a researcher test. Even you can win the best researcher award if you answer all the questions whatever it is related to the problem. But what my suggestion, after becoming a researcher, also take in one moot court as a mooter, so that you can speak confidently. So do not stick in one role. You also need to become a researcher also. In another moot, you also become a mooter also, because both role will help you in the advocacy life. So both are required. So let's see what is planned. So if there is a 2 months, let's say uh, this month is August, September, October. October month there is a moot. Let's say example. So what is the plan of week 8? So first week to week 8. So let's say first you need to analyze the week 1 and week 2. You need to analyze problem. So precedent research, you need to plan for the cases, which cases need to be taken, and what are the, you need to understand the facts of the case. You can't go outside the facts of the case. You can't assume the facts, whatever given you need to take as it is. Next, week 3 to week 5, so you need to draft the memorials. So appellant's memorial, that is if case is appealed from district court to high court or high court to supreme court. So appellant and respondent, they will defend their case. So week 6 to week 7. So why you need appellant and respondent both side preparation? Because you don't know in preliminary round what you will argue, whether it is respondent first or appellant first. Because in draw of lots, that is draw of lots, there in coupon they will write appellant and respondent and they will take one by one. So we don't know what we will get first. So if I get appellant, so preliminary round 2, I will get respondent. If I get respondent in preliminary 1, I will get appellant in preliminary 2. So you need both side preparation. So practice bench and oral arguments, rehearsal. You need to prepare yourself week 6 and week 7. Don't do mistakes that, like, some students will do some mistake. What is that? Tomorrow is submission, like moot court. Today night they will prepare the memorials and submit it next day. Then what happens? You have a memorial written submission, but orally practicing is not done. Then it is very difficult to clear even preliminary round, because you don't know whatever is mentioned. Even you prepared that memorial, but you unable to speak without seeing the memorial. Sometimes judges, what they will do, they will test. Please don't read the memorial. Judges say, without seeing memorial, argue the case. Then what you need to do, without seeing, you need to be, a written submission is reference purpose. Everything you should be recorded in your mind, so that you can answer the bench. So it will happen only with the help of practice. So week 8, so competition again, the round, you will go for preliminary round, octa final, quarter final, semi final, so finals. So these are the plan. Again, the facing the hard bench, that is judges question. Final round, it is very difficult because high court sitting judges will come, or district court judges, supreme court judges. So what they will ask the question, in-depth question, it is very difficult to answer. It's not a direct in the memorial. We need to analyze. Whoever memorize the facts of the case, or whoever memorize the law, they unable to answer in front of judge question. So what is my suggestion? Do not memorize. You need to understand the law. Why we need applying this right now? Why we will not apply in uh, another circumstances? What are the exceptions are there? So we need to think different angles. So we need to answer with understanding in front of the judges. So memorization not work because we unable to recall everything. So developing composure and adaptability under judicial fire, this we will develop. So in front of judges, how we need to answer, how we need to behave. So we need to respect judge, like my lordship. We need to address the male judge. If female judge, my ladyship. So we need to bow like this, and we need to thank them like much obliged. So these are the terms you need to use in the moot court. So next is surviving and interruptions. So pause and listen. When judges asking the question, you need to pause. Like you need to take some time to think and listen what they are asking. So immediately stop speaking. Never speak over the bench. So our duty is to listen and argue the case, not argue the judge. So our duty is to convince them. We not fight with judges. So we are the advocates, are the officers of the court. So our duty to explain it in clear manner. So that is, some mooters will argue in front of judges. So that is a wrong behavior. So you need to be polite, you need to be patient, because their questions are very difficult, we unable to answer. So the anger will come out, but we need to control our angers. So direct answer, that is you need to answer first yes or no. That is. Next is pivot back and structure, that is seamless from answer back to your core roadmap. After answering, you need to come back whatever you are explaining. So next is maintain courtroom etiquette. I told you need to behave properly. That is exhibit unwavering defense and professional pose. So you need to be professional. That is your wear. That is black coat, black tie. As a advocate, we will wear white band after becoming an advocate. But before becoming an advocate, as a mooter, as a law student, we need to wear black tie. So that is the etiquette. We need to behave properly. So through high pressure environment, it is high pressure. Accurately simulates high stakes appellate court, so teaching students to manage anxiety, that is stress and anxiety, and think to their feet. So accept experiential learning. So ensure first real court, you will become as a lawyer, you will think as a lawyer, as an advocate in front of the judge, that is moot court, in the moot court. So ensure your first real court appearance isn't the first time you face tough question from a senior judge. So it is not a first question you will face, because entire life you will face that tough questions. Even after becoming an advocate, the questions will be not easy. It is a difficult questions. So we need to protect the client. We need to answer for those difficult questions, because client don't know to convince the judges, or some clients unable to answer the tough questions. So they, what they will do, instead of becoming party in person, they will give the case to advocates, because advocates know the legal procedures to convince the judges, or to argue that answer the tough questions. So that's the reason they will give a fee for advocates fee, and they will give the cases. So professional and career edge. So again, after becoming completion of your law, it will helpful for your career. How? Like, while law firm and senior counsel actively hunt for seasoned mooter, what law firm is looking, everyone completes law, many university, many students are there, many lawyers are there. After graduating, there are many people are available, but why you need to be selected in that particular firm? They will see extra knowledge. So if you are a mooter, that is, you participate in moot courts, they will think that you know the procedure, you know drafting also, you know argument like convincing also. So they will take you in their firm. So it is a weightage in your resume. So I prepared the table, that is differences of traditional classroom and moot court experience. That is primary focus, passive learning and settled statutes, and active resolution, unsettled legal issues. There is unsettled legal issue. So we will, in moot court, we will argue the case. So it is passive learning, traditional classroom. So root memorization and written exam, I said. So tomorrow is exam. What every student will do today night, they will read, memorize it, and in the exam they will think what they memorized. But some student can be recalled because of sharp memory, and some students unable to remember what they studied, because last 5 minutes what I said is forget. Then how we can expect yesterday nights? So some students, so this problem will arise. Oral advocacy, drafting and quick pivoting, that is, you will draft it, you will orally practice it in front of mirror, or in front of your team, mooter 1 and mooter 2 and researcher. So feedback, so letter, grades and term paper, that is certificate, you will graduated, your marks. So here real time criteria, so practice by practicing judges. So the judges will give you feedback, whatever your performance is, whether it's good or not, way to improve. So employer value, standard academic baseline, so proof of real world litigation capability. So this is the reason moot court is very important. Like skill prioritized by top law firm, deep legal research. So research is required. 95% they will focus the firm whether that candidate, that law student, have a understanding of legal research. Whether if I give any topic, they able to research it properly or not. They will check. So oral advocacy, the person need to advocate, need to be argue, right? Without argue, he or she cannot become an advocate. So pressure resilience 82%, and brief and memorial drafting 78%. These all I took percentage as an example. So law firm recruitment partner ranks moot court participation as a top indicator of candidate readiness. So this is step up to the bench, that is transform your legal education into advocacy mastery. So if you don't know law, still you can participate, because after you, let's say family law 2, that is Muslim law, it is second semester, you are in the first semester, that Muslim law topic is came, facts of the case. If you start your research in the first semester, then it will help you in the second semester. While you are reading, you already read it in the moot court, you already solved. So it will help you in academics. And let's say you completed your education like the constitution 1. So after completing constitution, you get a moot. related to constitution. Now you will apply whatever you learned in the moot court. So either way, whether you studied or not, it doesn't matter, but you need to participate in the moot court. So my personal experience, I participated in Alliance University. I'm that is my first moot, and I unable to qualify for next round, that is top 16 quarter final. I lost in the preliminary round. So I unable to perform well in preliminary round 1, but I performed well in preliminary 2, but 1 and 2 will be counted. So why 1 is not unable to perform? I tried my best, but opponent team is seniors. They performed very well and they took the scores. So what my learning from the first move, I understand where I did mistakes, so I not repeated in the next moves. So I again in the preliminary round, I'm not disqualified, I'm qualified in top 16, I'm qualified in top 8. So again in top 8, semi-final, to go to the semi-final round top 4, that I am unable to qualify because again it increases, level increases, the difficulties increases. So in out of top 8, I performed well, but I and my team, but unable to qualify because they will see entire score, overall scores. So sometimes overall score, sometimes one team or opponent team will move to the next round. So in national moods, again I qualified, my team qualified top 8. I won best performer award. But what my in preliminary round best performer award. But what my suggestion to you all is, first you need to understand the moot court, why it's important, basics, how to argue, how to convince, everything you need to observe. Next, after 2 or 3 moot, you able to clear the preliminary round. Even you can clear top 16, top 8 and top 4, and even you can enter in the final rounds. You need to apply the strategies. So now I am in the final year. So I get an opportunity, many opportunities for moot court. I will try my best to win, at least to go to the semi-finals. If possible, go to the finals. But my aim is participation. The winning is not my aim because it is winning is difficult. It depends upon the judges' decisions, and we can't control. Like whatever I am convincing, the same way is opponent team also convincing in their perspective. So it is difficult to say that we will win the moot. So it is very impossible. But what I say is try to participate. So winning is, if you won, okay, it's very good. If you lost, still don't worry, because many students after losing they will never participate again in the moot courts. They will think it is a failure. It is not a failure. It is a key to success for next upcoming moots. So thank you so much for listening. If you have any doubts, you can ask me. I will share this PPT, that is PDF, to WhatsApp group. If you are a part of the group, you will get notification. If you are not a part of the group, you can join. I will uh, put that link in the descriptions. So please share with your friends so that other law students can also learn, understand the importance of moot courts. So many students don't know what is moot court in the beginning years, initial years. So they will realize in the final year why I wasted. They will regret why I wasted in the beginning year, why I not participated. So please do not do that. Initial stage, give your time for your last studies, and even I know some students are working and reading the law. So please take the time for moot courts. So it will give a very good experience. So thank you so much.